We're going to be talking today about best practices on resolving hospital liens, and I'm having a little trouble getting my slides to move, but I will get there. Forgive me. There we go. As I said, I've been negotiating and litigating hospital reasonableness for 15 years in a bunch of different contexts. Everything from working for an international insurance company's in-house counsel, where a large part of our function was to reduce these hospital bills, to a litigation law firm in Miami where we exclusively litigated the reasonable value of hospital bills and usually hospital liens in that context. Hospital liens nationally are a creature of either statute or contract. Now, there are some exceptions like Florida, which is where I happen to be, where we don't have a state statute, but instead have individual county statutes. But generally speaking, I'll call all of those statutory liens, and contractual liens are just liens that are similar to your letter of protection liens that effectively are created by agreement between the patient and the provider. 40 states and the District of Columbia have hospital lien statutes. I have them listed there. And in Florida, 9 of our 67 counties still have liens, and 9 states have no lien statutes. So in all of those states, and especially those states which do not have lien statutes, hospitals can and often do create liens on admission by adding lien language to their admission contracts. So it's important, no matter what, to follow the law and follow the facts of your individual case to determine whether or not there is a lien and how much that lien is, whether it's limited, whether there's equitable distribution provisions in your lien statute, and things like that. Here are a few examples. California does have a lien by statute. For those of you in California, you're very familiar with Statute 3045. It does limit liens to reasonable charges and to 50% of the proceeds, so that's helpful in your limited policy cases. Illinois also has a statewide hospital lien statute limited to reasonable charges or 40% of the proceeds, and the lien rights cut off hard stop at the date of settlement. Ohio is one of those states that does not have a lien statute. They're also, I've lost my screen again. There we are. There are no county ordinances that I'm aware of, so hospitals, like anyone else, can create a lien by contract, but do not have a statute. And as you likely know, especially those of you in states with robust lien statutes or ordinances, those statutes carry all sorts of exposure and legal peril for the lawyer as well as the patient. And so those kinds of teeth typically are not in the contractual liens. The contractual liens are very simple lien rights that are added to an admission agreement. Florida, as we mentioned, does have 9 counties that still have liens after the Supreme Court here declared all the others unconstitutional for a long-winded reason we don't need to go into. All of our ordinances do limit the liens to reasonable charges, but it does not include any equitable percentage, unlike the other states we just looked at. What that means, unfortunately, for those of us in Florida facing hospital liens against our settlements, we do have the possibility that if the reasonable value of hospital care exceeds the settlement amount, the hospital can take the entire settlement. No legal fees, no legal costs even, and nothing to the patient. Hospital gets the whole thing as a matter of law. However, most hospitals, as most of you here have experienced, will agree to an equitable distribution of a limited settlement, especially, as Teresa mentioned, if you're willing to reduce your fees. Because hospitals know that as a matter of business, if they were to take entire settlements, the lawyers would simply stop taking cases that involve their liens, and they're getting free collection work out of us, unfortunately, so they want to keep doing that. Texas, another example, does have a statute. It is limited to reasonable charges. The Supreme Court has confirmed that reasonableness requirement. A good case for those of you in Texas, which you're probably aware of, the Haygood case, did give the right to discover a bunch of things in determining that reasonable value, and also specifically mentioned that the cost of care is relevant to reasonable value, and we're going to get into cost of care a little bit later. I'm going to go kind of move ahead because I know that we are on the clock here. Maryland is an interesting state, very challenging to argue reasonable value because it is the last what is called all-payer state in the country. That basically means that hospital charges are similar to the rates that are paid by managed care and by Medicare, and they are approved by a commission, which all together means that essentially hospital bills in Maryland are legally determined or deemed to be per se reasonable. That's tough. The statute itself does limit liens to work comp rates. However, work comp rates are effectively limited to the commission rates, which again are effectively the full bill charges. So all that said, though, we do have a lot of success in reducing bills in Maryland. I think it's for the same business reasons that I just mentioned. So reduction strategies. If we're talking about reasonable value, which we almost always are, unless it's a limited settlement, how do we figure out what that is? How do we get there from here? Your hospital, forgive me, problem again. That most firms and attorneys, what happens is they basically engage in blind negotiation from the full bill charges down. Both parties typically frame that as a discount from the full bill charges. The hospital will offer a discount or the attorney will ask for a discount. And that sort of begs the question, is the full bill charge due in the first place? And the reality is it is not. So you're not really asking for a discount when you're asking to pay reasonable value. You're offering to pay the full amount that is due and owing, both as a debt and as a lien. So I am very careful with my team to make sure we don't frame things in those terms. I don't think that we're seeking a discount at all. I think we're offering to pay the full undiscounted reasonable value of the claim. The fact that they pretend that they are entitled to 3 times that amount does not somehow make it a discount. What I find from most attorneys that I speak with is, you're kind of stuck with accepting the best discount you can get, to use the wrong terms again. So a 20 to 30% reduction from full bill charges is pretty common. When I have my live presentations, which seem like a thing of the past, but I know we're going to get back to it one day, I always ask firms up front, just to get the context and the lay of the land, what do y'all usually expect? What do you usually get as reductions on these hospital liens? And I hear basically 3 answers. Number 1, we always expect at least 20% off. Number 2, average around 30%, not bad, not great. And if we can get 40% off, that's a home run. We don't get 40% on those cases. That's what I hear. And there's not that there's anything wrong with that. That is literally the very consistent message I get from firms across the country on this issue, regardless of what state you're in. But I do believe there's a better approach, and I believe that at least here at Synergy, we employ that better approach. And what I call that approach is inverting the argument. And it really goes back to what I was saying before about discounts. If you can define that reasonable value, you no longer are seeking a discount. You want to define that reasonable value and negotiate up from there, as opposed to starting at this unrealistic, unsupportable number that nobody pays and asking for negotiating back and forth for discounts off of that unreasonable amount. It just doesn't make sense. So defining the reasonable value is important. And what we define that reasonable value as is the cost of care plus a reasonable profit. I believe that a jury of lay people would probably find that to be the easiest to understand definition of reasonable value. How much did it cost to render the service, and what is a reasonable profit above that cost? Luckily, with hospital care, you can determine the cost of care. It can be derived from a document that every hospital submits to the federal government under oath every year. That is called a hospital cost report. It's part of the Medicare compliance requirements for all hospitals that accept Medicare, which are effectively all hospitals. And once you use that data, you can hone in pretty well on the cost of care for any hospital bill in this country. Experts who testify on reasonable hospital charges routinely testify that a reasonable profit would be somewhere between 40 and 50% above costs. Principally, the probably best or most well-known expert in the country is Dr. Gerard Anderson out of Johns Hopkins. He's testified before Congress on this very issue in excess of 40 times. Every time his testimony is that cost of care plus a reasonable profit above cost is effectively the reasonable value. And he's written him and his team have written several scholarly peer-reviewed articles on that exact methodology. What I've found, we want to try to translate that into what we see in practice, right? So what does that translate to as far as a reduction from an unreasonable full bill charge? Typically, reasonable value when viewed from cost up tends to be about 20% or 30 to 35% of the full bill charges. It can be more or less depending on what services were rendered. All the cost to charge ratios for the different departments are different. So if a bill is very heavy on CT scans, for example, it's going to have a much lower reasonable value than a bill that's very heavy on operating room time, which has a higher cost to the hospital of rendering. But good rule of thumb, 20% of bill charges, 35% of bill charges is where we see these numbers falling once we do all the fancy analysis. So when you invert the argument, as I've recommended here, what kind of results do you see? And I wanted to give you a quick case study. This is from an actual case that we assisted with. Full bill charges of $95,000. Line negotiations is what I call the traditional way this is done, negotiating down from full bill charge, in other words. The typical results, according to most of the firms who've answered that question for me, are a 20% discount, a 30% discount, or a 40% discount. And as you can see here, at a 20% discount, you're offering the hospital a 641% profit above cost on this particular bill. In other words, we analyze the cost of care and the reasonable value here. And at a 20% discount from full bill charges, 641% profit. I think that's hardly anyone would agree that that is reasonable. It's a very high. But at a 30% discount, you're still over 400% profit. And at a 40% discount, remember, that was the home run that most firms report to me when I ask about it. You're still offering the hospital a 344% profit. So once we inverted the argument, we determined the reasonable value, and it was estimated to be approximately 20 grand in this case. And as you can see, that came in right about where I said it would, around 20% of the full bill charges. So that was arrived upon by taking the actual cost of every line item on the bill, adding a 50% profit above cost, brought us to $20,000 on this $95,000 bill. And then we negotiated up from there, again, inverting the argument. In doing so, 25% above that reasonable value is 25 grand, which is a 74% reduction from full bill charges. A 50% markup above the reasonable value, above 20,000, would be 30 grand, and that would be a almost 70% reduction from full bill charges. And even if you were to pay twice the reasonable value, in other words, we know that experts would testify that the reasonable value of this $95,000 bill is 20 grand. However, we're offering you 40. You're still at almost a 60% discount. So you can see how much better the results are using this inverted argument methodology. So on the $95,000 bill, what happened in this particular case was the hospital had offered a 30% discount before Synergy was engaged. And as you may or may not be aware, that is typically, we have a couple of fee structures. That's the principal fee structure for lien resolution. We do charge a percentage of savings. So we ask in advance, did the hospital offer you a discount first? And if they did, we only charge a fee on additional savings. Here, there was a 30% discount in place. That doesn't mean we can't help. And in fact, here's a good example of how we did and can help. Synergy then was able to negotiate this after analyzing the bill for reasonable value. And we got the hospital to accept 50% above the reasonable value, 30 grand on this $95,000 bill, which means that there was an additional $36,000, almost $37,000 savings by engaging our services. Even after our fee, the additional savings to the client was over $30,000 by using us. So perfect example, hospital offered a 30% discount. As you saw on the previous slides, that's right in the middle of what most firms will accept, somewhere between 20 and 40%. So this was one that the firm probably, before they engage us, had a pretty robust discussion about whether they should engage us or just advise the client to accept the 30% discount. I'm glad they didn't, because the client ended up with an extra $30,000 in their pocket by recommending letting us take a shot at it. So how do we do it? Well, we basically have packed our ammunition box tight with everything we need to fight these hospitals on these bills. Just remember that there's a very unfair playing field here. Hospitals have all the data. They have everything and we have nothing, right? Like the plaintiff's lawyer, the general plaintiff's lawyer who's negotiating this bill with the hospital, basically all they have is the bill and the hospital's opinion of what you should pay. They don't have anything else. And so that was really our goal here, was how do we get the ammunition we need? We have coding experts, of course, and hospital billing experts in general who can look at all the charges and remove all the errors, the non-billable charges. Ironically, you don't see a lot of billing errors going in that direction. There's always extra stuff on the bill. We remove all of that, of course. And then we calculate the hospital's cost of care for your specific bill, add that reasonable profit of 50%, as I said, and then we apply it to the law in your jurisdiction. All the jurisdictions are different, of course, but generally speaking, reasonable value is the common thread between them. The basing the opinion on the hospital's own sworn cost data not only gives us additional data to use, which is important, kind of leveling the playing field in and of itself, but it also is their data. It's data that they created, that they swore to under oath and submitted to the federal government. They can't say it's wrong. They can disagree with the methodology. They can disagree with their interpretation of the lien law and the cases interpreting it, but they can't say that data is wrong, which to me has proven to be a very valuable weapon in this fight. I wanted to touch quickly on something that I've coined as the lien debt dichotomy, and I think it's super important. Also think that it's widely misunderstood in this lien context. What I mean by this lien context is, unlike all of the liens that Teresa just described, and there's a lot of them, as you heard, all different flavors of reimbursement liens. That's a provider that has been paid already, so they're out of the picture, and you're dealing with whomever is trying to get reimbursed for that payment. There's no debt associated with those liens. Nobody owes anybody any money. You don't ever owe your insurance company back money when they pay your benefits, unless there's this lien right that's created by the recovery. And that lien right is the only right that you're concerned with. It's the only thing you have to deal with because there's no debt. Well, in these direct provider liens, which are providers who've not been paid yet by anyone, it's completely different. There is a lien, as we said in the outset here, based on either a statute, county ordinance, or a contract. So there's a lien against a settlement, which is nothing more than a security interest against the settlement. Sort of like a mortgage secures your home loan to your property. This lien merely secures your debt to your settlement. So there is a lien, and that lien carries with it both ethical and legal exposure for the attorney, of course, and that is important. But there's also this debt, right? There's always an underlying debt when it comes to a direct provider lien, like a hospital lien or a letter of protection lien. That debt and lien difference is super important, and it needs to be explored before you engage in negotiations, including whether it's contractual or statutory. So if you determine there is a valid lien against the settlement, you basically have your marching orders. You know that you have to get it resolved, so you have to review the language of the statute or the contract to understand what that lien really is, what it's limited to, what it isn't limited to. Of course, the common law comes into play in many cases because a lot of this stuff's been interpreted by the courts over and over again. Then you effectively do all the stuff that I just went through. You estimate the reasonable value, and you also, I recommend anyway, and this is certainly what we do, is you calculate the equitable distribution amount. Even if there is no equitable distribution available under the statute, as is the case in Florida, or if there is an equitable percentage baked into the lien statute, you need to run that math so you know which is better, right? If you get a better reduction through an equitable argument, either through the statute or otherwise, you want to lead with that, remembering that there may be a debt balance, because resolving a lien does not necessarily resolve a debt. It just severs that security instrument. The debt is still outstanding, although, as most of you have probably experienced, most hospitals in these negotiations will agree to a lien release as full and final payment of the debt. Once you've made that estimation of which is better for your client, the reasonable value or the equitable reduction, you negotiate for the better or the lower of those two. Just keeping in mind again that many of the lien statutes either create or eliminate the opportunity of equitable distribution. So you do have to follow the specific law in your state on what the deal is with equitable distribution. Even if, again, even if there is not the ability to equitably distribute, most hospitals will entertain the idea because they got to maintain some sort of a business relationship with the plaintiff's bar, or else you all will stop bringing them money at all. Now, what if you find out in that initial pre-negotiation investigation, you find out there is not a lien, and that these medical bills or hospital bills, whatever the case may be, are merely debts that your client owes to their healthcare providers? First of all, you want to obtain that written confirmation right out of the gate. You want something in writing, whether it be a simple as an email chain back and forth where you finally convince them to agree that they do not have a lien, or some providers are much more, amenable to just sending you a letter that says we're not pursuing lien rights, we have a debt of $100,000, right? You need that in writing, and then you know that your ethical requirements with regards to this settlement are satisfied. You don't have to pay a debt out of your settlement. I have not yet seen any state that requires that debts to mere creditors be paid out of a settlement, even if it's accident-related care. If there's a lien, of course, you must protect that lien in trust in pretty much every jurisdiction until it is resolved amicably or by adjudication. But debts, it's not so. Any creditor could say they want you to pay out of the settlement, but the reality is, if you're a mere creditor and you have a debt, you can pursue collections of that debt, and that is about it. So once you've gotten that written confirmation, you need to determine what your client wants to do. Do they want to resolve the debt from the settlement proceeds or not? If they do, then same as we said before, you negotiate for the reasonable value or some other methodology to get you a reduction that everybody is equally unhappy with. But if they do not want to pay the debts out of the settlement, you can disperse. In fact, in many states, this issue's come up, Florida being one of them. You must disperse. Most of the states' trust rules, which I've reviewed, do say that you have to disperse if there is no legal claim to the settlement proceeds. And to the settlement proceeds is important. That doesn't mean a debt against the person. It means an attachment to the settlement. And so dispersing to the client is really their call. I just obviously recommend a pretty detailed CYA kind of letter in your file that the client has been made aware of the debt, that the patient will at some point be pursued in collections. The hospital might sue them. You're not representing them if they do, all that good stuff. So more importantly, though, because there's two kinds of clients, as you all know, in this regard. Many clients really don't care about a big hospital debt because they're not going to pay it, and they're not going to be able to collect from them. They're basically judgment proof. So they say, why would I pay it? I want my $30,000, $30,000 that's being held in trust. I just want it, and I'll deal with the collections action when and if it comes. And it may never come, or if it does, it won't hurt them any. Other clients, it's the most important thing in the world, right? Like, I don't want this going to collections. I want everything resolved. That's what I paid you for. I get it. So you got to figure out who they are, who your client is in that regard. Getting that signed acknowledgement from the ones who do want the money, though, is a very important step for you to protect your firm and to inform your client, frankly, that this isn't just walk away. They're going to end up dealing with this at some point. So in conclusion, our services always result in a net pre-suit savings, or else we don't charge you a fee. Now, we do have some small lien administrative fees on really, really little ones. That's a different issue. But generally speaking, hospital lien resolution through Synergy is a zero risk proposition. We either get an additional savings to where you are, or else we don't charge you anything. So I like to think that it is always in the client's best interest to at least call us. Let us give you our opinion on whether we can add value and how much, and give us a shot, because if we don't get it done, it doesn't hurt. And you've, if nothing else, completed your obligations to your client. The fees,
thanks very much, Michael.
You're very welcome. You're welcome, Dan. Thank you, guys. And thanks, you guys. If anybody has any specific questions beyond, we're of course happy to answer them here. But I also wanted you to see I'm available by email or by my direct line anytime. So please feel free to reach out.
Thanks, Michael. And while Michael hands the presentation from Miami to Chicago, just again at a high level, I mentioned the synergy passion at the beginning of this presentation, and one of the things that we are most passionate about, and I know that I am personally, is the fact that these hospitals are taking our uninsured plaintiffs or those on public benefits and billing them at a made-up retail rate that is 10, 20, 30 times what any other insurer would pay is ludicrous at best, and we are so proud of the opportunity to prevent that from happening with the hospitals that you're dealing with.